Riccadelli M. Tahan, Criminal Evidence, OLBN 22E22. What is burden of proof? Burden of proof, also called burden of persuasion or onus probandi, is the duty of party to present evidence on the facts in the issue necessary to establish his claim or defense by the amount of evidence required by law. What is burden of evidence? Burden of evidence, also called onus evidentiae, is the burden of going forward with the evidence. What is the difference between burden of proof and burden of evidence? Burden of proof never shifts and it remains with the party upon whom it is imposed, while burden of evidence shifts from party to party depending upon the exigencies of the case in the course of the trial. What is meant by presumption? Presumption is a rule of law stating that because a basic fact exists, another fact also exists. It is an inference as to the existence of a fact, not actually known or conjecture based on the past experience as to what course human affairs ordinarily take. What are the two classes of presumption? Presumption juris or presumptions of law, presumption hominis or presumption of fact. What are the two basic types of legal presumption? Conclusive presumption, disputable presumption. Give two examples of conclusive presumption. Whether a party has by his own declaration, act, or omission intentionally and deliberately led to another to believe a particular thing true and to act upon such belief, he cannot in any litigation arising out of such declaration, act, or omission be committed to falsify it, also known as estoppel in Paris or equitable estoppel. The tenant is not permitted to deny the title of the landlord at the time of commencement of the relation of landlord and tenant between them, also known as estoppel against tenant. Give at least 10 examples of a disputable presumptions. Unlawful act was done with an unlawful intent. That a person intends the ordinary consequences of his voluntary act. That a person takes ordinary care of the concerns. That evidence willfully suppressed would be adverse if produced. That money paid by one to another way due to the latter. That a thing delivered by one to another belonged to the latter. That an obligation delivered upon up to the debtor has been paid. That prior rents or installments had been paid when a receipt for the latter one is produced. That a person found in possession of a thing taken in the doing of a recent wrongful act is the taker and the doer of the whole act. Otherwise, the thing which a person possesses or exercises acts of ownership over are owned by him. That a person is possession of an order on himself for the payment of the money or the delivery of anything, has paid the money or delivered the thing accordingly. Who can contest the legitimacy of a child born of a wife to a wife? Only the husband can contest the legitimacy of a child born to his wife. What is the doctrine of res ipsa loquitur? State the requisites for the doctrine to apply. Res ipsa loquitur is a Latin phrase which literally means the thing or the transaction speak for itself. The requisites of res ipsa loquitur are: the accident was of a kind which does not ordinarily occur unless someone is negligent. The instrumentality on agency which caused the injury was under the exclusive control of the person charged with negligence, and the jury suffered must not have been due to any voluntary action or contribution on the part of the person injured.